Good afternoon, Steve Brooks here for Friday's Inside Look by Brooks. Today's topic is, how much money do I get to keep after my personal injury settlement, or out of my personal injury settlement? That is the second most asked question I'm asked. The first most asked question is, how much is my case worth? Both of those are very tough questions to answer, but I'm going to focus on the second question, which is, how much do I get to keep from my personal injury settlement? And I'm going to give you a good lawyer answer. It depends. There's a lot of depending factors. So it depends on what attorney you choose, number one, because this law firm, Brooks Law Group, charges based on a contingency fee. And the contingency fee, what that means is that we are going to charge our fee only if we are able to negotiate a settlement with the insurance company or go to a trial and get a verdict and get paid from that verdict. So you'll never have to pay any upfront money for attorney's fees or costs at the Brooks Law Group. So out of the total settlement, the first thing we will deduct are going to be the costs that we actually had to pay as a law firm for medical records, for a court reporter, for postage, hard cost. And then the attorney's fees. We charge based on the Florida Supreme Court approved form. So the cost and fees. The other thing that has to come out of the settlement, if you used your health insurance to pay for any of your medical care that was required because of this accident, then your health insurance will probably have a lien against the settlement proceeds. And that's all by contract. Your health insurance contract will essentially provide that if a third party, the at-fault party, runs a stop sign, causes injury to you, and you ultimately have to go to the hospital and use hospitals and doctors, and the health insurance has to pay, they look at themselves as being as harmed as you because they've had to pay money because of this third party's negligence. So if you sue or go after that third party and collect money, the health insurance has their hand out, and this is all by contract, and they are entitled to be repaid out of the settlement. As attorneys, we have to honor that contractual provision. If it's Medicare that pays, Medicare has a statutory right to have a lien on the proceeds. And again, we will negotiate and pay Medicare out of the settlement proceeds. If you happen to live in a county that has what we call a lien hospital, and you go to one of the lien hospitals and they perfect their lien appropriately, those monies would have to come out of the settlement. Normally, we, when you have an auto accident in Florida, your PIP, your no fault, will pay for 80% of your medical care up to $10,000, but you still have a deductible that you have to pay out of pocket. Most medical providers will forego collecting on that until your case is settled, but they want to be repaid out of the settlement. So we like to keep our clients in good standing credit-wise, and we always advise them to pay those amounts owed to medical providers, doctors, hospitals that may fall under that deductible. There are times when you as a client, maybe you don't have health insurance, but you desperately need medical care, surgery, far and above the $10,000 that PIP will pay. And so there are doctors and medical providers that will accept what we refer to as a letter of protection. Letter of protection is a letter to the medical provider, to the doctor or surgical center, signed by you, the client, me, the attorney, that says if they will provide this medical care, that we promise to pay them out of any proceeds from a settlement or a jury verdict. So If you've signed that and I've signed that and we've given that letter to induce the doctor or surgery center to perform services, then you're going to be legally obligated to pay that doctor or that surgery center or hospital out of your settlement proceeds. So those are the main areas that we are required to subtract and pay out of the settlement proceeds. And then obviously, after all of your bills are paid, then you, the client, can get the balance. So, and you know, so much of this depends on, it's circumstantial, you know, whether you had healthcare, whether healthcare paid for anything, whether there was a letter of protection, whether you had Medicare, how much your costs were, how heavily litigated your case was. If you're involved in a case that maybe has questionable liability, then that case may be heavily litigated and your cost may be really high, sometimes astronomical, you know, to pay doctors to come to depositions and testify. Those are expensive consequences of litigation sometimes. So your cost will vary based on the facts of your case, the amount of insurance available, the level of your injuries. There's a lot of factors that go into, you know, what ultimately has to be deducted from the settlement proceeds. So if you have any questions about settlement proceeds or your personal injury case, feel free to contact me at steve@brookslawgroup.com. I'll try to dialogue with you and answer any questions you might have. Otherwise, I hope you have a great weekend and look forward to seeing you next Friday for Friday's Inside Look by Brooks. Have a great weekend. Thank you for joining me today.